This short guidance video is one of a series produced by JISC Legal in supporting staff who are directly involved with business and community engagement or BCE activities within their institution. JISC Legal are one of several services that are part of the JISC BCE programme. Where your institution has worked with another organisation or partner within BCE, you might have produced a product or service that could be commercially viable. In such a case, you will want to promote and market that product or work. But how do we do this legally? In marketing and selling products and services, an institution will need to comply with both the Data Protection Act and the Privacy and Electronic Communications Regulations. We're now going to hear from John Reid, an associate from McRoberts Solicitors, who will deal with the legal issues of selling together. Why is email marketing an important issue for BCE activities?
Well, Jackie, email is a very effective marketing tool because it allows you to target a group of individuals with a very focused marketing campaign. Now, what's more, all of this can be done at the click of a mouse and at a fraction of the cost of other more traditional forms of marketing activity. But the one problem with email marketing is this issue of spam, unsolicited commercial email, which ranges from, at best, being a nuisance to at worst being a lot more sinister, a vehicle for criminal activity. A few years ago, the Privacy and Electronic Communications Regulations were introduced to tighten the rules on email marketing. Now, the regulations set out a general principle that you can only send a marketing email to an individual if you have that person's prior consent. So if an email is sent without such a person's prior consent, it breaches the regulations.
Who actually benefits under the regulations?
Well, that's an interesting question. The regulations benefit individual subscribers. So for instance, if JISC Legal wanted to send me a marketing email to my personal home email account, it would need my consent because in this respect I'm considered to be an individual subscriber. However, it'd be perfectly legitimate for JISC Legal to send me a marketing email to my McRoberts work email account because in that context, the subscriber is McRoberts. It's a corporate subscriber. So it's important to bear in mind that the regulations only benefit individual subscribers.
How do you go about getting and demonstrating consent?
The best approach is to get the individual to specifically opt in to receiving the marketing emails. Now, I'm sure you've seen these things on websites where there is a statement that says, if you wish to receive marketing emails from us, then please tick here. The advantage of that is that by ticking the box, the individual is expressly demonstrating their express consent. But there are other options. You don't have to do it that way. In some circumstances, depending upon how the statement is worded, a failure to opt out, a failure to object may actually constitute consent. So again, you may see a statement on a website or on a flyer. By submitting this registration form, you're consenting to receiving marketing emails from us, unless you specifically indicate your objection by ticking this box. So that's following an opt-out format. And the Information Commissioner says that depending upon how the statement is worded, that can be sufficient consent for the purposes of the regulations. The key factor is that there has to be some form of communication by which the individual knowingly indicates consent.
Are there any exceptions?
There is an exception if you are marketing to your existing customers and you're simply telling that customer about your existing goods and services. Well, in that situation, you do not need express consent, but you have to make sure that you give your customer an opt-out. You have to give that customer a facility whereby they can say to you, I do not wish to receive email communications from you anymore. So I think at this point, I think it's worthwhile summarising that if you're dealing with a new customer, then get consent. Either do that by way of an express opt-in or a very carefully worded opt-out. If you're dealing with an existing customer, then you don't have to get consent, but you have to give that customer the ability to opt out to receiving future marketing emails. And it's also worth bearing in mind that you have to abide by good data protection practice. So when you're collecting the details, make sure that they're collected fairly. Make sure that the individual knows the purposes for which their data will be used, in other words, marketing, and give them the chance to object to the use of their data for those purposes.
What about third-party mailing lists?
You have to be careful with third-party mailing lists because you cannot be certain about the matters to which that individual has actually consented. The list has been compiled by another party. You haven't been involved in the process, and therefore you would have to make sure that any consent that has been given works as an effective consent for you, because to the extent that it does not and you use that list, then you're in breach of the regulations.
What happens if you do breach the rules?
If you breach the rules, the individual could refer the case to the Information Commissioner for consideration, and you could end up receiving an enforcement notice from the Information Commissioner. And of course, if you do not comply with an enforcement notice, it constitutes a criminal offence and could result in you being fined. Also, where the individual has suffered some loss, then they have the right to sue you to compensate them for that loss. They have a right in damages.
As John has already explained, there are certain restrictions that will apply to marketing by email, SMS, phone and use of marketing lists. There are also regulations regarding consent, particularly where that's unsolicited marketing or direct marketing. And John's already discussed with us the opt-in and opt-out approaches. In each case, there must be clear identification of the selling organisation, and remember that under Section 11 of the Data Protection Act, an individual can apply to prevent any future marketing. If you have a specific query on this or you'd like further information, then please contact us. You can do that by phoning us on our help desk or sending us an email.